What do you want to do? What do you want to do for your future students? The people you're living I'm like, what did I do this to myself? So I gotta squeeze this in. That's why I was like, I'll get I basically pull it on something, and I'm just spewing.
Are you doing the presentation?
First class, I said I'm trying to be practical. I said, if you want to know about equation, you have to You know what they say in the Supreme Court when the justices come in? Oyez, oyez, oyez.
Yes, sir.
All parties having business before the honorable court. Seriously. All parties having business before the court. Not when it's in session. I've physically been in the building. Are we on or off?
On.
We left it on?
No.
You turned it back on? Okay, thank you very much. Oh, I know where I want to start. So, a question may have come to your minds, although no one's asked it, as to, since this is a real estate law course, why was I spending so much time talking about the estate process and the wills and things like that? And what people don't realize is that when a person dies, that is a title transaction, because title is transferring on death. Remember my number one rule, title transfers on death? So this is all part of how real estate gets transferred, not necessarily voluntarily. Actually, most people, death is typically involuntary. That's why this is relevant. And I, you know, in the course of my career doing title work, I used to read, I brought the abstract in early on, right? The big thick book. So what would happen is you would see the estates in there as part of the title examination, and you would see that what happened when somebody died. In fact, one of my early tests that was given to me by one of my bosses was, in fact, it may have even been an interview test for my second job, was to go through an abstract that near Homestead in South Dade, we were talking about Homestead, the next town to the north is called Perrine. And this was actually the estate of Anna Hester Perrine. Because many, not all, because Homestead doesn't count, but many of the communities that we see in South Florida, those are family names. There was a founder, Morris Cooper, Cooper City, R.P. Davey from Boulder, Colorado, the town of Davey, Lyons Road, Lena Lyons. I mean, these are all, no, there was no Homestead. I think Miami is an Indian name. But actually Fort Lauderdale is named after a major in the Civil War Army. So there's
North
all
or
kinds
south?
of, what's that?
North or south?
I don't know. I could guess, but I don't know. It's fun, it's a good question. Make that a homework assignment.
I will.
Okay, so I just wanted to mention that because that's the relevance to the topic. Now, hopefully I'm not going to get into too much of this detail, but I want to talk about homestead and not the city. Homestead is what is referred to as the legal chameleon by the legal scholars because there are so many permutations of it and so many different things that are affected by homestead, the concept of homestead in Florida, that it's all over this stuff. Homestead goes back to the earliest of Florida. It's a concept in the Florida Constitution, and it goes back to the 1845 Constitution and is carried forward in one form or another. And the original concept, and really still the overriding concept, is to protect the family. The definition of what can be your homestead varies between whether you're out in the country or in the city, and that is defined as being inside of a municipality. Here in South Florida, almost everything is inside a municipality, and that has a very odd side quirk because the definition of homestead is outside of a municipality, you can have up to 160 acres. Inside of a municipality, a half acre. Problem is when you go to, let's take Weston for example, or Davie, where a lot of the zoning says that the homes in Davie have to be on acre lots. So this becomes something of a problem. How it gets resolved, I don't know. But the law says a half acre inside a municipality. So what is homestead? Homestead controls many different things. Number one, it controls descent and distribution. So going back to the estates, that we went through the spouse and the lineal descendants, but if it's homestead, the spouse gets a life estate and the remainder goes to the lineal descendants. The concept being that if it's the homestead being your primary residence in Florida, that they want to preserve the right of the family to be able to live there after you're gone without being disturbed. So regardless of testate or intestate, the spouse would get the right to live there for their life, and then the lineal descendants would get it. Or they've made a change in the law in recent years to allow the spouse to elect to have a 1/2 interest outright, and the lineal descendants get the other half, and that's the situation where the spouse says, I don't want to live there for the rest of my life without my husband, I want to sell it, so we're going to split it. I'm going to get half, I'm going to give the kids the other half.
So she can, in that case, the wife would either do a life estate or get a half interest.
Right, she either gets the life estate, she can stay there for her whole life, or she can elect to take a half of the proceeds in effect.
But that's if there's no will in place that made her 100%.
However, a beautiful segue. What about the homestead laws restrict the wills?
What?
Yes. So, remember, we're protecting the family. So the homestead is not subject to devise
Okay.
if you are survived by a spouse or minor child. Except, if there is no minor child, it can be devised to the spouse. This is an important concept here.
So, hold on. So,
I'll go back through it again. You cannot devise the homestead. You can't give it away to anybody if you are survived by a spouse or minor child. Except if there's no minor child, you can devise it to the spouse.
And devise means what is that?
Will. My will. Devise. I give, devise, and bequeath to my beloved spouse, my home, located at. For this purpose, and because we've talked about it in detail, a devise would also include a grantor trust. Grantor trust, remember we want to stay out of probate, so we're going to put everything in trust? But a trust in this case is a will substitute. It stays in the grantor trust. I create a trust for my benefit during my lifetime. I can revoke it. When I die or drool, somebody else gets it and takes over. Okay?
So
It's a will substitute. So it cannot be devised in a trust, just like it cannot be sent elsewhere, besides if you have a spouse or minor child.
So just to go back over the within a municipality, outside of a municipality, you've got 160 acres. Outside, half an acre inside.
Right. That's just the extent of the homestead.
That's the extent of the homestead, okay.
That's subject to these protections and restrictions. Protections are coming.
Okay. Are those different protections, whether you're within or without, or is that
No.
just dictating
That's just
the land
the
area?
extent.
Okay,
The protections are the same. That's just the land area.
okay,
Okay?
I follow.
So, devise is subject to restriction, whether it's in a will or in a trust. Okay? Next, alienation of homestead. A person may convey or mortgage the homestead joined by their spouse. It used to say a married man joined by his wife, but of course they fixed that in probably one of the more recent changes to the Constitution. It was 86. You can, so you cannot, a person who owns the homestead in their own name, people cannot sell it and cannot mortgage it without the joinder of the spouse. For that reason, when you see a deed, you will always, or a mortgage, you will always see a recitation in the deed. John Smith, a single man. John Smith, a married man joined by his wife Mary Smith. Mary Smith, an unremarried widow. You're always going to show marital status in the grantor clause of the deed to determine whether or not it's homestead, whether or not somebody needs to join. Now, suppose it's not homestead. If it's not homestead, you can do anything you want. There's no restriction. Therefore, you would have further down in the deed, like under the legal description, a paragraph that says, this property is not the homestead of the grantor who resides at, and you put their home address in. So you're setting forth a fact right on the face of the deed to establish why the spouse does not need to join.
And a homestead is only means you live there. That's all it really means.
It is your primary residence. You qualify for your homestead, you file for your homestead, but that does several different things, including establish these protections as to that piece of property. Yes?
So then, if you're buying the house and you're married, and it wasn't homestead, now you have this deed, but you're not putting your spouse in it, that's allowed?
Yes.
Okay. So you're not, they may have some legal rights in terms of the court, but
You can, incoming is fine. It's outgoing that the restriction is.
Gotcha.
Now, in your example, where you're going to run into a problem is if you're not paying cash. Because if
You're
if you
not
go,
allowed
if
to
you,
get a mortgage.
if you go to get the mortgage,
Yes.
then your spouse has to join.
Right.
And that the problem also comes up where at the other end of the happiness spectrum, when people are getting divorced or they're planning on getting divorced, and let's say one spouse needs to mortgage the house to fund the divorce or to get money, the man can't go and just go get a mortgage because even though they may be legally separated, living apart in the divorce process, he's still married under the Constitution, and therefore she has to join. Now that always turns into a discussion, but you can have a joinder limited to releasing spousal rights as to the homestead. So that the wife would sign, in that case, the mortgage without incurring any obligation or responsibility. Okay?
So it's 2 to buy and 2 to sell in this state?
Absolutely not.
Or it's 1 to buy, 2 to sell?
Correct.
Okay. So
You missed that.
Unless you're
You missed that.
getting
There's
a
just-
that's what I'm saying is unless it's cash, it's, okay, if it's cash, it's 1 to buy, 2 to sell. If it's a mortgage, it's 2 and 2?
Right.
Got it.
Okay? So, interesting way to put it, but okay. It's technically correct. The homestead offers protection from creditors. Under the Florida Constitution, your homestead is exempt from forced sale. That means if I have a judgment against you, I can't take your house. I can't kick the family out.
That's right.
Okay? That's the law. It's not subject to why. So, if they don't pay what? Exception time. Thank you.
Okay.
Exception time. So, there are certain things for which there are exceptions. Work that's done to repair or improve the homestead. So if you bring in a roofer to put a new roof on your homestead and you don't pay the roofer, you cannot hide behind the homestead because you've hired that roofer to fix your homestead. Any work done to repair or maintain the
So
homestead.
it's not just capital improvements, it could be
Any repair or
any
improvements,
repair.
yes. Or a consensual lien. A consensual lien would be the mortgage, something that the owner, joined by the spouse, consents to by contract, a mortgage. But not a third-party judgment because you didn't pay your car insurance or something like that.
Oh,
Okay? The other homestead characteristic/benefit is taxation. There's an exemption from assessment
Does homestead protect over like illegal activities, or?
yes, actually it does.
Huh. Which one?
Now, when you say illegal activities, it's a
I
little
like forget El Chapo's house over here. Does his house get seized? Like if he has a house in freaking Florida.
It can't be seized. It can't be seized to pay fines and things like that. And I don't think,
Can a lien be imposed on it or no?
no,
They just can take it.
it's homestead. No, it's homestead.
Oh, wow.
So what happens is where you see the abuse of that is in the beautiful community immediately to the north of us, Boca. That's where we say all the unindicted co-conspirators live. And so they will move from wherever and have all this cash they've skimmed off of whatever thing they're doing up wherever they come from, and they'll buy these $3, $4, $5 million mansions for cash. And it's their homestead, and it can't be touched. So when somebody sues them for whatever scam they've done up north, the money is safe. Now there are new things that I think I touched on the FinCEN targeting order, where if you buy something for over $300,000 and it's cash in the 3 counties, you have to file a tax form. But that's really for looking for money laundering. It doesn't affect its homestead exemption. Now for taxation, the first $25,000 of your assessment for taxes. Remember, houses are assessed. What? Okay, so first $25,000 of the assessment for homestead is an exemption that comes off. Now, obviously that number was established when homes were worth a lot less money. So, if you had somebody lives in a $125,000 house, that's going to have a big effect. That $25,000 is a large percentage. If you live in a $5 million house, it doesn't have a whole lot of meaning. But there's been some case law over the years where you have the people that because they're so wealthy and they don't care, because that $25,000 I think saves you about $200 in taxes.
okay.
So the rich people didn't care about this tax exemption thing because it was such a small amount of money. So they stopped filing. It's an easy, you do it when you first buy it. It's one filing and then it's automatically renewed unless there's a change in your circumstances. But they didn't want to be bothered with it because they couldn't get the help to go do it. So Mr. Kraft he probably lives up north anyway. So all of a sudden, when they tried to claim the exemption from forced sale or something like that, the courts held, well, you haven't established this as your homestead. You didn't bother to file. So we don't think this is your homestead, so it's not exempt anymore. So that became a little bit of a problem. Now, technically, as a factual matter, if they were able to prove that it was their homestead, they could take advantage of the exemption, but it becomes an uphill battle. The other problem that they really held that the filing was key to it, wait, hold on a second, was Florida has a cap on increases in assessments on homestead. This is really important. So when you have a homestead, the county cannot increase what they value your home for taxes by more than 3% a year. That's the cap on assessments. Save Our Homes, it was called Save Our Homes, Save Our Homes Amendment. That's I haven't heard that because it's a long time ago. So what happens, what's that?
It's in the real estate book.
Yeah.
Yeah.
In our book?
No,
No.
I mean like for,
Oh, take a real estate license. Yeah, well, it's important. So you have to, what they've held is, and this has been upheld, that you can't get the Save Our Homes exemption on this cap if you don't file for homestead, because they're both taxing things. You can still prove what you need to prove to get your protection from creditors, but you cannot take advantage of the cap on the assessments if you don't file an established tax part of the homestead exemption. Then they came up with something a few years ago, because, I'll use myself as a perfect example. I lived in a house in Davie for 21 years. I had the benefit of this cap on my annual increases in exemption. Kids are off, they go off to school, they move out, they establish their own lives. Now half the house is empty. Now it's time we want to move to something smaller. Well, what would happen would be, if you move to something smaller, even if it was worth less money, you've been enjoying a lower tax bill because of this cap for 20 years. Now, you're going to move to something smaller, and your taxes are going to go up, even though you have a less expensive property, because you've had the benefit of the cap. So they came up with something called portability. Portability allows you to take the cap, the differential between what you're being assessed as with the cap and what your fair market value assessment would be, and move it to the new residence. As long as you do it within a year and a half or whatever, by the end of the tax year following the tax year in which you sell. And this lets you keep the benefit of this Save Our Homes exemption and move to the downsized new home.
So you're forwarding the ratio.
Correct, exactly right.
Okay.
Not the ratio, the actual amount. It's not the ratio, it's the amount.
So how do they determine, let's say you have husband and wife, and husband buys a house, wife's on the mortgage, same thing with the wife is on the mortgage, and can they have two separate claims? Like, can the husband say that's his homestead, and can the wife say this is her homestead? Or how do they determine who's supposed to live where for what period of time?
The general answer is no.
Okay.
However, there are legitimate circumstances
Yeah.
where husband and wife, usually older, will separate. They will live separately, but they will not get legally divorced.
Right.
In that circumstance, you could have two separate homesteads.
What about in the circumstance if somebody lives here for work 6-7 months out of the year, and then they have another home where the spouse lives
Where?
in Florida? What would be the
You can only have one in that situation. You can only have one homestead. You just said it's for work. It's not your primary residence.
Okay.
Okay? Now, I will tell you, in talking about these exemptions and the homestead and such, other states, notably New York State, has a very aggressive Department of Revenue. And think about it, there's a lot of people that come down here as snowbirds. And they come down and they buy a home down here, and they want to live down here for the winter or a period of time, and they want to take advantage, and somebody tells them, oh, all you can do is live here for 6 months and 2 days, and you're a Florida resident, and you can, and that's fine maybe for qualifying for the homestead, but the New York Department of Revenue, where they have not only an income tax, but an estate tax, which we have neither in Florida, New York Department of Revenue looks at more than the number of days. And in fact, they look at the number of days if you happen to be in the state of New York, whether it's for business, for visiting, for living there for the summer, they'll count the number of days, and they will look at things like, where do you go to your doctor? Where do you go for the holidays? Where are the family photo albums? Where's the big house, where's the little house? Because they want to see, is your Florida residency really your residence, or do you have 1 foot in each state? They're very aggressive that way. And they will look at more than just the number of days.
You want to know how long you're on the phone with someone in New York too, or?
I don't know. But if your business is in New York, let's say, okay, I'll give you, that's almost a good question. So, suppose you still have, you're in the manufacturing business, you make cheese, okay? And like Kraft cheese. And the factory is still, sorry, he's the guy of the day. So your factory is in New York State because they have dairy cows that roam the mountains. And you're here at your 8-month-a-year residence in Palm Beach because it's very close to the shopping center where they have the really nice massage parlor. So, just tying it all together. So, your example, you're on the phone, and what are you doing on the phone? You're talking to the manager in your factory in New York State. What are you doing? Aren't you doing business in New York State?
No.
Sure you are. You are conducting business in New York State.
That's a reach.
Yeah, that is a reach. That's a reach.
But in reality,
No,
where's your
follow.
income coming from? Are you participating in the management? That's my point. Are you participating in the management of the New York State business? Yes, you're running the place. You're running the place from your phone. Just happens that your phone is a little further away. Okay? And by the way, with today's VoIP phones, you could have an extension of the factory phone system in your home in Palm Beach just plugged into your router.
Yeah.
So you are actually, so in that situation, they would say you're doing business, you're conducting your New York State business, you just happen to be sitting here.
So they're looking where your income.
Where is your nexus? Where are you really? Okay. Real estate taxes. Briefly, I've touched on assessments and taxes being assessed. I don't know if I mentioned this last week or not. Taxes are assessed as of January 1st of each year. Well, actually, I think I was on the phone with a client. Taxes are assessed as of January 1st of each year. It is a snapshot. So the assessment is based upon the data that they have at that time, as of that time. So they are going to look at what's gone on in the prior year. So if you want to challenge your 2019 assessment for your property, you have to present data to the property appraiser of what happened in 2018. Whether they were comparable sales or valuations or whatever it was that happened last year, so that the value as of the first of the year is what we're looking at. I have personal experience in some of this stuff. I bought a condo we closed in the end of January of 2018. We went to contract in 2017. I didn't close in 2017, so I didn't qualify for my homestead exemption for 2018. So I got dinged for a pretty big tax bill. So when I got my preliminary estimate of what my taxes are going to be, it's called a TRIM, T-R-I-M notice, where you get a notice around August of each year. It's the property appraiser's notice of what the proposed taxes are, and it triggers the timing when you can go and challenge your tax assessment. So I went back to them and I said, look, I only paid this for it. You're assessing me for more. I said, I know I closed in January, but my contract was dated in November. So really, I could have closed, but I didn't because I don't want to pay double rent. So here's what it was worth then, and here's the other 3 units that closed in my building. There was 1 unit higher price, but it was way, way much higher. So I got them to bring my assessment down to what I paid for it, which is fine. Because, and what's important about that is that that's where my cap's going to start, my 3% cap. So, which will now qualify for this year, as well as the portability. So it's as of the first of the year. Your assessment is as of January 1, it's the assessment date. That's when the taxes become a lien. That's when the value is fixed. It does take them some time into the year to come up with the numbers and look at the historical data, which is why the trim notice doesn't come out until August. And then we pay our taxes in arrears starting in November. But I'll get to, yes?
How far back can you challenge the assessments? Like how many years? 1 year?
Yeah, and there are deadlines. You can beg and weasel about the deadlines, and they will work with you in most cases, but you can't go backwards. They can go backwards. That's fun. And it's usually, for them going backwards is usually when they find out that the homestead was taken, the exemption was taken improperly. And the biggest abuse of that, and the one that people get caught, and where it causes the most problem, is when somebody dies. Because somebody dies, in December, and you don't bother to tell the property appraiser, and now the following year, you still have the benefit of grandma's homestead exemption, so the taxes are staying low, because remember that cap on assessments, that goes away if there's a transaction. If it's sold, if it's transferred to another owner, if it's inherited, it gets readjusted to market value. So all of a sudden, now that house is not, that homestead exemption doesn't apply anymore because the owner's gone. There are certain circumstances, very few, where it can pass along. If it's joint ownership, it doesn't change. So if it's joint tenancy with right of survivorship or tenancy by the entireties, it doesn't change, it doesn't jump.
So is the 3% cap, is that a state?
Yes.
Okay.
So if they were to pass, if they were to die, and it's now transferred to the family member, wouldn't it go through the same cycle as when you're doing a sale? That if you have homestead and you buy it, you essentially are taking the benefit that they had, and then you're, the following years that you're paying?
No, so portability, it's not the taxpayer, it's not the same taxpayer. That cap goes away. It's a transfer, it gets reassessed at fair value. The portability dies with the person.
But when you're collecting, and I may be wrong with this, when you're collecting taxes on the sale, if you're buying a piece of real estate, and that property was...
You mix in closing prorations here, right? You talking about closing prorations?
Right, it wouldn't be looked at the same way?
Don't mix apples and oranges.
Okay.
It's actually very dangerous to do the closing prorations without taking all of this into consideration. Because you don't know, so here we are, it's February, almost March.
Okay.
So in 2018, there was a homestead exemption. So you look at, right now, what you can look at is a 2018 tax bill.
Right.
I was going to get to the point that the taxes are billed in arrears. Our tax bill comes out in November for the calendar year with a 4% discount. It's not delinquent, it's not due and payable in full until March of the following year. So, this makes people from up north crazy because it doesn't work that same way. So, the tax bill for 2019 does not actually have to be paid without penalty until March 30th, 2020. It's payable in arrears. However, they give you a discount of 4% if you pay it in November, and that discount decreases by 1% per month. So it's 4% November, 3% December, 2% January, 1% February, full bill in March. Okay? March 30th it becomes delinquent, March 31st, it becomes delinquent, which means it's past due. And then there's penalties and fees. So, what happens? The government runs on a budget, the state government, the local government. That budget depends upon revenue. Just like if you're operating a commercial building and you need rent to make your pay your expenses and do things like that, their money's not coming in. You haven't paid your taxes, there's no revenue. So, they sell a tax certificate. They actually have a public auction. Usually takes place around June, after the taxes become delinquent at the end of March. They sell a certificate at public auction to investors. And the interest rate that the investors make on the certificate depends upon how much they bid for the certificate. It used to be, years and years ago, that you would always get 18%. It was just always 18% was the starting point. What happens is the higher they bid for the certificate itself, the lower the rate goes. And it's a bidding process, and of course, now the market rates are so much lower than that, the bidding goes up. These people hold this certificate, but then of course the cash goes to the municipalities so that they can pay their bills. So with the taxes, actually, while it doesn't show paid on the tax rolls, the tax cash money goes into the system where it's supposed to go to pay for county and city government from the sale of the certificates. Now let's go back to the delinquent property. The property is subject to the certificates. The certificates can stay out there for 2 years. At the end of 2 years, the holder of the certificate has the right to apply for a tax deed. Also takes place at an auction. The property will be sold just like a foreclosure for the unpaid taxes. If that happens, and there's notices after notices after notices, and the notices go to anybody they see with an interest in the property. Anybody with a mortgage on the property will get a notice. It goes out, but of course, in very few cases, you have somebody that owns a property for cash and they don't live in this country, and the notices never get to them. And in a few cases, that tax deed will be sold. And if that happens, any interest in the property gets wiped out. So the tax deed will wipe out a mortgage and any other interest in the property. Yes?
So it supersedes a mortgage?
Yes. Remember when we talked about, remember that really fascinating talk about the loan documents? And I said that that's where people were falling asleep because they were so interesting. So the only thing that can we say prime a mortgage or wipe a mortgage is the taxes, which is why most lenders take an escrow for taxes. Go ahead, another question?
Yeah, so I mean, well, there wouldn't be a mortgage because the bank would obviously pay for the taxes.
Correct. Most of the, but you know what?
Bacon sloppy.
What's that?
I said bacon sloppy too.
That's correct. I have had situations, yes, I mean,
We have to give them a
real
chance-
stories for the real files.
We have to give them a chance to pay for it.
Oh, yeah. There's notices after notice after notice. There's notice at the certificate level. There's notice at the application, there's notice that an application paper has been filed. There's notice that the sale is going to occur. And that all goes to the owners and to the mortgagees of record. Little problem occurs, or maybe not so much anymore, but little problem occurs because the mortgages get sold. So when things were going, churning, what would happen is you would go to ABC Mortgage Company, and ABC Mortgage Company would originate your loan, do all the paperwork, file the mortgage, and at closing or right after closing, ABC Mortgage would sell the mortgage to Bank of the Ozarks. Or better yet, would sell it to, come up with a name, I don't know, sell it to Barnett Bank. Barnett Bank got taken over by NCNB. NCNB morphed into Bank of America. So where do the notices go? When it goes, that's an example where it's going to flow through. But when First State Bank of Central Florida gets taken over by Centennial Bank, and people don't know, and the tax collectors aren't given notice of these changes, all of a sudden the notices are going to not get to Centennial Bank's corporate office in Jonesboro, or wherever they are. Okay, I think I knew that. And so there is an absolute possibility that bank's going to get wiped out because they're sloppy. Or their tax monitoring office isn't doing, I mean, I've had some banks that they just weren't paying attention. They weren't monitoring the taxes and they had lots of loans and boom, they would lose it. There's nothing you can do. Nothing you can do.
Can it be bought, like I saw a client that bought a tax certificate and then somebody else bought another tax certificate for the same property,
Different year.
different years. So
Correct.
what happens, let's say client 1 has a 2016 and client 2 has a 2017. At the end of 2 years, who is it that can apply for that tax deed?
2 years after when?
After the first person bought it or the second person bought it?
Okay, so-
When is that,
So
when they became delinquent? When is it?
each clock starts differently.
Okay,
So the 2016 taxes, the certificate would be sold in June of 2017
right,
because it became delinquent in March of 17.
right.
So it's technically, the date to look at is basically June of the third calendar year,
Okay.
if you look at it that way. So your 2016 guy can apply for a deed in 2019,
Makes sense.
2 years after the certificate was sold.
After the certificate.
Now, the guy with the next year's certificate, the guy with the 2017 certificate, can redeem the guy ahead of him, but what happens is that when you apply for the deed, you have to at that point pay all other outstanding taxes.
Right.
So when 2016 applies for the deed, he's going to pay anything else that's outstanding, so 17 is going to get redeemed, in your example.
I followed.
Are we okay with that?
So if 16 claims the deed, he has to pay off 17.
Yes.
When he applies for the deed, yes.
How many days after it's considered delinquent do these things get issued?
So this year.
Delinquent at the end of March,
Right.
certificates in June, deed 2 years later.
Thank you.
And then the title process afterwards, if they're wanting to resell it, is a whole nother.
Yes. you know, the title, technically the title is good, but the title underwriters that are insuring the title require to do a quiet title action
Quiet title.
to make sure that everybody is properly wiped out.
Have you had any clients that buy like this?
Oh, sure. So, I mean, it's not all the time. And there are, we had people that used to make a nice living, or at least do investments, when the certificates were selling for 18%, that was big business. People just put money into it, and the worst that can happen is they get their money back with interest. And it was real money. There are possibilities of challenge, because just like the banks can make mistakes, sometimes the tax collector can make mistakes as to where the notices are sent or how they're sent. I've seen case law where absolutely 100% there was proof that the property owner said, I don't live here anymore, send my tax bills here. And that wasn't followed. So, but there was proof, certified mail, whatever it was, the tax collector got it, and they ignored it. It didn't get put into the system. And so the entire process was able to be set aside, which is why that quiet title action is important. So, although I don't know how you're going to get served properly with litigation if nobody knows where you are.
Right.
Okay? Any other questions on the taxation? I'm going to switch gears. Talk about land use and zoning a little bit. What's that?
Yeah, that was
This is really difficult. I mean, it's just really nitty-gritty. It's a lot. You're not used to it.
All right, before we go into land use and zoning, I love these questions. It's so hard. I mean, okay, my favorite question still was, when is the midterm? But so how many questions on taxation? A few of them. How's that for an answer? I don't know.
Yeah, no, I'm just saying, we're looking at the book. The book that says these are going.
Yes. I mean, I'm not gonna. There are some things I've sent to you where I've tried to make it clear when I say this is important.
Yeah.
Okay? I'm not going after you on minutia. There's no, there are concepts here. I'm trying to work on the concepts at this level. I'm going to some of the detail in part because you're asking good questions about the detail. Whether they're practical questions or they're theoretical questions, I'm trying to answer the questions, and sometimes the questions generate answers that's a little more detailed than you really need for what you're trying to do here. So I'm trying to stay with the concepts. Actually, yeah. So I want to talk about land use and zoning a little bit. Well, so the exam, I'm trying to get it to about the same 45 questions, just because, I don't know why, but I thought since that's how we did the points allocation, I thought that would be easier. I did say to you that I'm going to do some true and false questions interspersed with the multiple choice. It means you have less guessing to do. You only have one answer, true or false. I am making a very conscious effort and I'm spending a little extra time to make sure that the questions don't have multiple right answers. I don't want to have to go through that exercise again. I'm debating still. I'm not sure what I'm going to do. I know we talked last time about a little bit about coming up with an essay question. And I just to have like extra credit. Don't look like that. Although I will repeat my admonition from the last time when we went over the exam that the multiple choice questions do not require supplemental essay answers. So you don't need to do that. So appreciate it to the explanation. Don't waste your time on it. I haven't decided what I'm going to do about adding on an extra question, just because I don't know. I'll think about it. I'll see what I can come up with.
So, are the tax lien certificates sold at the face value? When you were saying the feds and the yield goes down as you add more, it's because they're sold at the face value
Plus interest. Well, yeah. Well, I guess they would come down. They definitely it's face. It's probably face plus 18% as the starting point.
Okay.
And then the higher you bid, the more the 18% comes down.
Got it.
the purchaser, I'm going back to tax certificates.
Sure.
The purchaser who bought it, let's say for example 2016, can they have first priority to purchase 2017, or that just goes thrown off?
It's
the
auction.
Auction?
Yeah.
Off the
There's
bat?
no priorities. Now, what they could theoretically do, I'm not sure this would be well, no, you wouldn't want to do this as a certificate holder. You wouldn't want to do this as when you're applying for the deed. You have to pay them. You have to pay them when you make the deed application. As a certificate holder, if you paid off the taxes to avoid somebody else buying the certificate for 17, then if your 16 certificate got redeemed, you'd have no way of getting that other money back. You have no rights to it. You just made a gift to the property owner, and you have no donative intent, so you don't want to do that. And you're protected because you get the right to apply for the deed before the guy behind you does. So it's not something you would
Yeah,
worry
but how can you tell somebody has the deed 5 years before that?
Well, it doesn't go 5 years.
How far back? Oh, it goes just year to year, 2 years, right?
It's
Okay.
right. And by the way, how do you find that out? You go right on the tax collector's website and you see if there's certificates outstanding. We do it all the time to make sure the taxes are paid before we do a closing. Very easy. You have to know that. And whether it's delinquent or not delinquent, you want to know if they're paid. Because right now, 2018 taxes are due and payable. We're still in February, so there's still a 1% discount. So before I do a closing, I need to know. Now, the problem is when I have April 1st closings, if they're unpaid, we don't know exactly what the interest and penalties and advertising fees are.
But you can only purchase it after March.
After the delinquent, well, actually, the certificates are purchasable in June.
Okay.
Because they have to do, there's a process including advertising them for sale.
Got it.
Okay? Land use and zoning. Try and run through a few of these things. So, zoning is a classification of properties to allow what can be done on the properties. It's done so that you're not living next to a factory. It's regulation of land by the municipalities. Usually at the county level, but can also be done at the city level. It can mean business, industrial, residential, general commercial, community activity. They're just some examples. Business could be anything. There's different types of business zoning, and the different layers of business would be different kinds of intensity. You would have a neighborhood business. You might have a convenience store, you might have a gas station on the corner, you might have a retail store, a grocery store, things like that. Or there's more intense businesses where you might be doing car repair or other things that are more disturbing and intrusive. So there's different categories as to what would be permitted in a given area. Residential also has different categories based upon density. Whether you want to have, whether they want to allow one home to the acre, which is, for example, what they do in the nicer neighborhoods in Davie and Weston and places like that. So you have big pieces of land, and you don't have so many people taking up. Or you can have higher number to the acre. You can have apartment complexes. You can have high-rise apartment complexes, and it all depends upon the zoning and how many units are allowed in any given area. There's always issues of what's going to happen next in the next area over. For example, if you have a nice neighborhood of acre homes, you don't want necessarily a subdivision to go in there where they're going to build student housing immediately adjacent. You want to have buffers. You want to have the density increase gradually over a period of time. So maybe next to the one to the acre, they're going to put 4 houses to the acre, and then maybe some townhouses, and then apartment complexes, so that it's progressive as it gets closer to commercial. Now, if you have retail or large retail, like say the Sawgrass Mall, then the next door neighbors of the Sawgrass Mall may not care that there's 2 high-rises sticking up in the middle of the Everglades. Well, they're just stuck there. The people that would object to that, although there's very little they can do about it, are the people in Plantation Acres that have the 1 to the acre homes that now have folks up in the high rises with the binoculars looking down at their pools.
So awkward.
It's terrible. But that's you know, you can't totally prevent stuff like that. Now, in order, you can fight zoning changes.
You said they allow so many units per, what was that?
Per acre.
Per acre. So like, how about like downtown areas where there's literally high-rise apartment buildings, like multiple in a block almost?
Right.
It's like, so how, what,
It's a function of the zoning.
That's the zoning.
That's
These
the
requirements,
zoning.
okay,
Yes.
yeah.
Just gonna get there. You know too much. So in some areas where they want to encourage certain types of development, they'll do what's called an overlay district, where there's regular zoning, but now for this neighborhood, they're going to put special zoning on it because they want the high rises to go there, or they want apartment construction along Federal Highway, or something like that, because they're trying to improve the tax base, they're trying to do it in a particular neighborhood, and they're trying to encourage development.
Okay.
So they'll allow more
So
density.
this can be changed.
Things can be changed, oh, sure.
Like, I mean, like, not easily, but like, how often periodically?
Oh,
Does it change?
it's relatively easily.
Oh, it is relatively easily.
Well, okay, so here's what
I
happens.
don't know what you're saying.
What happens is, when you go to change zoning, it's a public hearing, and it has to be advertised as a public hearing. And that's when the people in pitchfork and torches come out. I had a situation in Davie where we were representing a large big box retailer who will remain nameless, but they might be based in Arkansas. And everything, it was a big vacant piece of land, and staff was all in favor of it. Everything was approved at the administrative level, and the last thing that had to happen was it had to go before the town council. And the citizens came out. Because for whatever reason, the citizens viewed this as the evil empire. And they came and they actually they made enough noise before the commissioners that it was turned down. Eventually, believe it or not, the same exact parcel was approved for another big box retailer. Do you know what site I'm talking about? Oh, okay. Well, a lot of, I will tell you, as much as I've danced in some of my examples, there's enough of you in the room that know the city well enough that you've all pegged my examples pretty well. But I did say the city, so, you know. Anyway, yes, it was Target. But Target either was viewed as less intrusive, or their design was such that it didn't adversely affect the surrounding areas quite as much. So that's what happened at that parcel.
Target is just more people associated as being higher class than lower.
But that's, see, you can't do that. So when you, so here's an interesting,
What they do.
this comes to the, and I think I used the phrase NIMBY earlier on, not in my backyard. So you can't just say, I like the color of this store building better than I like the color of that building. I want red, not blue. You can't do that. Right? That is not a valid reason to deny. A valid reason to deny would be, this is a larger store, it has more density, its lights are facing into the residential neighborhoods.
Could it be based on clientele?
No, it really can't be. Unless you're, and there happens to be something going on right now in Fort Lauderdale, sure.
They're elected commissioners. If their constituents aren't happy with it, that squeezes them, doesn't it?
And then what happens?
They shoot it down.
And then what happens?
And it's sued.
Bing! Okay, which leads me to the next example I was about to talk about. Well, it's actually two. I'm gonna do the second one first and then the first one second. That's not first in time, first in right. So, the second one is something that's going on right now. Probably nobody, maybe 3 people in the room read a newspaper, a hard newspaper. But there's advertising because there was a proposal. Who was talking about the queue? So this is an apartment building that's downtown. Not far from where that is, there was a proposal by, I think it's the AIDS Health Foundation,
Yeah.
based out of somewhere in, I think they're based out in California, and they want to build a tower of affordable housing in south of downtown Fort Lauderdale, and it's there to help. Affordable housing has to be qualified at a certain, it's not necessarily for people who are sick, or have, it's just, this is what this organization does, but it provides housing for people with an income level below a certain designated standard. And there's tax benefits to it, and there's financing benefits to it, and it's being fought. So what happens is, they have an ad right now, where they've been running every week in the newspaper, and it says, what is the difference between this tower, which is their tower, it's a picture, and this tower, which is 100 Las Olas, which is a 46-tower mixed-use hotel and apartment, which is enormous and is going to cause all kinds of traffic. Why is this okay and this is not okay? And the ad is saying, could it be who's going to live in it?
Oh, I saw it on television.
It's not a permissible classification. You can't do that, okay? So there's your answer. You can, or yours. You can't do that. You can't discriminate based upon these people make more money so they can have a high rise. These people are poor, they can't. You can't do that. That's just general legal.
Unless if someone bribes.
Yeah. No, wait. So I want to get back to your point.
Unless.
Now I'm going to get to my first point, which comes second. Again, that's because of a subordination of points. There's another piece of property that is located to the west of US 1, just west of where the tunnel comes out on the south side of the river in Fort Lauderdale. And it's next to Smokers Park there. And it's a little 3-story L-shaped apartment building that's been there for years and years. A developer came along and they came up with a proposal to build a high-rise condominium there, like 20-some-odd stories. Well, part of the problem with it is that 20-story building there is going to block the view of several of the nice condominiums and apartment buildings in the area. That's not a reason. I look out part of my apartment and stare right into the next door, that's city living. But the ostensible reason that the people have been fighting it for have been where it's located. It's very, very difficult access to get onto the roads because you can't get onto Federal Highway. You've got to go completely around. And part of where that going around will take you is people trying to get there are inclined to take a shortcut that will put them through, not Victoria Park.
Oh, Rio Vista.
Thanks. The Rio Vista neighborhood, and you know where the nice homes are. But it will. Oh, you're chuckling for no reason. It's because it's not just that it's a nice neighborhood. The argument, the legitimate argument, is what?
The traffic.
Traffic.
And the
It's
linkages,
traffic.
yeah.
It's all traffic. So they're bitching about that. They're bitching about the access. These are legitimate reasons for it. So the developer met with the city because it was denied on the first go around. The developer met with the city, and they reached an agreement to reduce the density, to make the building lower, fewer units, shape it a little differently, and do it in such a way that it wouldn't have as much of an impact on the surrounding areas. Either whether it was the surrounding areas, the perception is, same as I mentioned, the apartment building by Weston, by Sawgrass that looks over the Plantation Acres neighborhood. This would kind of be looking over the Rio Vista neighborhood, but that's not the reason. The traffic pattern there is just awful because there really isn't a decent approach road. So they're fighting it over. So the developer said they tone it down. When they got to the final readings, and everybody's, oh, this is wonderful, they've reached an agreement, it's going to be less, it's not going to be as bad. They go before the commission, and they withdraw the agreement. The developer withdraws the agreement and says, we want to build what was originally approved by staff. And the commission said, no. We said, we got you back here because you said you were going to do this. Denied. Next step, lawsuit. Now, I haven't looked at the lawsuit. I don't know what's in the lawsuit, even if I'm not party to the lawsuit, nor are any of my clients. But in order to challenge something like that in litigation, you'd have to have a really good reason, and you'd have to show that the decision of the commission was improper. Because while they do have some discretion to do what their constituents want them to do, they cannot act in a discriminatory manner. They cannot act in violation of the law. So if there's nothing wrong with the project legally, now this one happens to have a little quirk, because I think it was a comp plan amendment they had to put through, or some comprehensive plan amendment, which is another, sorry, I'm jumping a little. So there was a legitimate basis for the denial. What's going to happen in court, we'll all see. So let me move down a little bit and talk about a few other points dealing with land use and zoning and these things. So in addition to the zoning things, there's other issues. There is a master plan or a comprehensive plan, and that is at a county level where they decide that this whole area here is going to be a certain type of development. And we want to encourage redevelopment, we want to encourage things to happen in these areas, and so we're going to allow different things here than we normally would in a regular area, or this is the only kind of stuff we're going to have. We want this part of town to be residential, this part of town to be commercial. There can be exceptions, but they'll do things like that, in much more detail than that, but that's what the master plan and comprehensive plan does. They can also do things called incentive zoning, where they want to bring something in, they want to redevelop an area and get rid of certain types of uses and improvements and then build it up. And that's where they may grant or create an area of increased density. So instead of having little low-rise garbage places, they might say, okay, we want to fix up this district and we're going to allow mid-rise apartments to go in there. I mean, I don't know what they did or how it progressed, but if you look at the Flagler Village area, the Flagler Village used to be crappy little buildings, and now it's mid-rise with a couple of high-rise, actually, apartments, all residential in there.
Same thing, Hollywood Boulevard, they just, yeah.
I'll never, that's a whole conversation.
Yeah.
Spent a lot of time on Hollywood.
Isn't it the CRAs that really?
No, they're useless.
Yeah. Really? You
Yeah,
think so?
yeah, they're useless. The CRA is the Community Redevelopment Agency. It's like an offshoot of the Chamber of Commerce,
Right.
but it's part of the commission, and their stated purpose is to help redevelop and bring in business. They don't do it. And it's, in my experience, especially when you talk about Hollywood.
Yeah, but I was gonna say, but they do hand out incentives.
Well, but, right, they try. They try. For a specific site, before a construction can be approved, they have to submit what's called a site plan. And the site plan establishes, as to the specific piece of property, where your parking goes, where your building goes, where your access points go, and actually lays out the plan on the site. That's why it's called the site plan. One of the things that the zoning does that's very important is it establishes, for the particular types of uses, the required amount of parking you have to have. So, for example, in a residential building, it used to be in a condominium, and it may still be in some areas, strangely enough, you have to have 1.5 parking spaces for each residential unit. I mean, you could drive a half a car. The reason it was done that way is because there's usually a unit mix of 3 bedrooms, 2 bedrooms, 1 bedroom. So they know that, or even sometimes it's just 2 bedrooms and 1 bedroom. So they, based upon the ratio, they can establish how many spaces will be needed, given that not even a 2 bedroom, you may not have 2 cars. You never know. But typical, let's say an office building, usually an office building would require 4 parking spaces for 1,000 square feet of office space. Medical offices have a little bit more density because they use smaller rooms and they have people sitting in waiting rooms, so they require 6 spaces for 1,000 square feet. Restaurants, they don't look at the entire facility to establish the square footage for parking. Because part of the restaurant is for seating, where people are coming and going and have to park, and part of it is food service. So in the food service and food prep areas, the chickens in the freezer don't need to park. The stove takes up space. You may have one person standing in the food prep area or 3 people in the food prep area, where the same square footage of the seating area, you could have 10. So the parking is adjusted based upon the food service area. Different uses, different things. Warehouse industrial would have much less parking. One other zoning classification, just to throw out so you know that it exists out there, is community activity. Community activity would be a place of worship, a school, a community center, a college, things like that. Those are non-commercial, non-industrial. They all have different uses and meanings.
And your mixed use stuff is,
Well, that's mixed.
they give you synergies, like for your parking ratios.
Let me talk about the parking a little more when it mixes, and I'll tell you how that can work too. What happens if you have a property and you have a use on your property and the city decides for whatever reason to change the zoning around you?
You grandfathered in?
Correct. So what happens is, if they change the law, if they change the zoning around you, and you're still there and you've always been there, then you are allowed to continue what's called a non-conforming use. It's non-conforming because it no longer conforms with the zoning. It was legal when you did it, but they changed the law. Now, you're allowed to continue the use, except if the use stops, or if the property is substantially reconstructed, either because of a renovation or a demolition or even a casualty. Under any of either of those circumstances, the use stops or the building is redone, which would mean the use will stop either, then you cannot continue the non-conforming use. There are a couple of exceptions, notably a special exception or variance. So you can, if you have a really good reason that you want to be able to do something that's not exactly allowed in the zoning, you can go and make application to the municipality and say, I need a special exception from the rule because, or I need a variance. I'm not sure if there's a difference, I don't know if they're synonyms or probably close to the same thing. But the key to either of those is it can't be self-imposed. It cannot be self-imposed. So you can't say, hey, I want to build something bigger and better on the site, but I can't because of your zoning, because I built too much here already. I want more density. Well, that's self-imposed. You're not going to get that. The only time, yes?
So that would be like if, again, in the past, someone had a location, they were doing manufacturing, like in Florida, for example, and it used to be industrial, they've owned it forever and a day, and so they're manufacturing stuff, it's industrial, commercial, now they've built a bunch of houses around it. If a hurricane comes through and like demolishes the building, instead of him saying, hey, let me spend money to again reconstruct, they basically say, take that money and go elsewhere so that this can no longer be there.
Well,
Like, is that like the premise, like
Now,
now that it's broken?
it's
just go
not that they're
elsewhere?
building houses around, it's that they rezoned.
Yeah,
where-
so okay, so if it gets rezoned, I'm just saying like not they're building
Now this
houses,
is
but
no
now
longer-
it's no longer zoned for that
For
purpose.
industrial, right.
If it gets broken down, the idea is that instead of spending all that money to put something right back where it's not zoned for, go elsewhere, the owner still keeps the land, but he probably has to go move his company to like another headquarters, so to speak, and they can just kind of choose what to do with that parcel.
Now, here's where you would go for a special exception or a variance type of situation in your example. Let's say that you are operating a last mile delivery service. Last mile delivery service is what happens if the over-the-road truckers that come and they deliver the Amazon packages from Orlando to the warehouse in the neighborhood. And then the little trucks leave that warehouse in the neighborhood, and that's how you get your same-day delivery, your next-day delivery, until they get the drones flying with the packages to you.
Yeah.
They're gonna use the drones to go out and pick up the scooters. Something's gonna happen like that. So, in that case, the business owner could say, I can't do my business in another location. There's no other location within 20 miles for me to operate my last mile delivery service, and this is essential to the area, that I'm able to provide this service in this area, and the only way I can do this is if you let me continue, if you let me rebuild. It wasn't my fault. It's not like I'm putting a new non-conforming use there. I had a casualty. The hurricane blew my roof in. So in that circumstance, I'm coming and I'm saying, hey, I need to stay here. I understand you've built houses around me. I've been here for 40 years, but I can't do my business somewhere else. That case, that's a good case where it's not self-imposed, and it's probably a good opportunity to get a variance. Okay?
Does non-conforming, does that run with the land, or?
No.
Okay.
If there's a transfer, then no, probably not. Unless the transfer is when the use continues. So for example, if you sell your business with the land, and the business use continues on the site, then that would be a continuation. It wouldn't be a change of use. If you sold it for a different use, then no. Parking variance.
So where do you put PUDs?
Turn the page. Zoning land use that I was talking about is governmental. The question was, where do you put a PUD? A PUD is a planned unit development. A PUD is established by private declaration of covenants, because you can have private restrictions on what you can do on property and what you can't do on property. So what happens is, you have a company that comes along, like Metropolitan Life or something. Okay, but I was going for Weston.
Oh, okay.
So
Gosh.
So you have a huge area that was established by a company that said, okay, we're going to create a city here. And so they create a declaration of restrictions that say, it's an overlay that says that we're going to plan this residential neighborhood, this residential neighborhood, this residential neighborhood, and this commercial area down here. That's a planned development. It's a little more than just a planned development. Typically, a planned unit development would be smaller in scope. That was much larger in scope. But it's a private declaration of covenants. It's a, any of you who have homes in neighborhoods, you would see that there's a declaration of covenants, be it in a neighborhood in Davie or anywhere in the city, if it's a community, and there'll be a declaration of covenants and restrictions. And it will say, houses have to be at least 2,500 square feet, garages have to face to the side, not the front, no home can be built closer than 10 feet to the property line, you can't have any exterior sheds, you can't have wolves, all kinds of things like that. But it's all private. It's all established by declaration of restrictions. You don't have to live with the declaration of restrictions because you don't have to buy a house there. So you are agreeing by accepting the deed to abide by this declaration of restrictions. It's contractual. You're acquiring that property is your acceptance of what's in those covenants. You've agreed to abide by them. They can be pretty broad and pretty far-reaching. They can also be, they have to be legally enforceable. They have to be non-discriminatory kind of things. Now, if you go back into ancient history, I may have mentioned this, there were discriminatory covenants and restrictions. They'll purge the public records, but you can't enforce them anymore. Who can enforce these restrictions? No, not the government. I know where you're going, because that's where I've got your pick. So basically two people, two entities. The homeowners association or property owners association, because remember, these kinds of restrictions can be established for commercial property as well as residential. In residential, it's an HOA, homeowners association. In a commercial setting, like an office park or something, it's a property owners association. They do the same thing. So they can come, the board can fine you or send you nasty letters and tell you you have to paint your house or mow your lawn or trim your trees and nonsense like that. So at the time they told me I had to take a dead tree out, a dead palm tree. So I called the guy to come take the dead palm tree out. He says, oh, you're in Davie. You can't take down a dead tree without a dead tree permit. Okay. Yeah, what do you have to do to get dead? And so I started looking at the paperwork, and I looked up at the tree, and I looked at the squirrels, and I looked at the iguanas, and I looked at the woodpeckers, and this was their home. And I said, I'm not taking the tree down. Maybe it's a condo. They were having, and so I just stopped. I wasn't gonna do it. But it was ridiculous that you needed a permit. In my opinion, it was ridiculous. You need a permit to take down a dead tree, because eventually that tree is dangerous. But so that was a letter, and nothing ever came of it. I sold the house. They took the tree down. But besides the Property Owners Association, other individual owners who are beneficiaries of this declaration of covenants could theoretically file suit to enforce the declaration of covenants as against their neighbors. It wouldn't be very popular, but it can be done. And I mean, it happens. I mean, unfortunately, like anywhere else, neighbors fight with each other. I don't like your satellite dish. Your generator's too loud. I can't. We had a situation where somebody, before there were standards, painted their house in hellacious colors. I mean, there were bright yellows and bright oranges, and it was just awful. Now, these people thought these were tropical colors and beautiful, and so we had a little bit of a to-do. And then the board passed, you have to get everything approved in this particular palette. And then compare the homeowners association to the scourge of the earth. Condominium associations.
Oh, yeah.
This is a form of ownership in life that was foisted upon us. That I'm proud to say I live in one. You take the same instead of taking our subdivision and our plats and things like that, you basically create a subdivision of boxes in the sky. And in a condominium, the condominium documents themselves define the units. And if you've ever had insomnia and wanted to actually read a declaration of condominium, when you get to the back, when you get past all the words, there's lots of drawings. And so what actually happens is, in creating a condominium, you have to have a condominium survey created, where the surveyor actually has to create the dimensions of each living unit, from the interior walls and such. And things that are not within the interior walls and not within each living unit are common areas, which are maintained by the association. That can be your hallways, your elevators, your stairwells, your lobbies, driveways, parking areas, all within the purview of the condominium association. And the condominium is created by contract, just like the Declaration of Covenants, except it's, bless you, except, oh, I think I said you overused this. Bless you. The Declaration of Condominium is a document that is created, it's a contract that's created that declares that this building is going to consist of these little boxes, and it can be done before the building is built. It can be done once you can convert a rental building to it. I'm not going, it's way beyond where I want to go with this, but same thing. There's rules, there's regulations, there's associations, and there's condo commandos. And like whether it's vertical or horizontal, the documents do the same thing. They regulate how you can use the property. Certainly, I don't want to say you can't subdivide in these situations, because theoretically you can't make them smaller, but you can combine two units in a condominium if the building allows it. There's all kinds of complications with that. But
I was going to ask that. Okay.
well, go ahead.
Well, when you combine them, because each individual condo has a folio number, what then becomes a legal description if you attempt to resell them?
Unit 302 and 303. And you'd have two folio numbers unless you join them, which you can do.
Okay.
You probably have to pay double the maintenance.
Yeah, you do. 'Cause
You should be getting 2 votes. However, in most condominium declarations, where it's 1 unit, 1 vote, doesn't matter whether you have the 3-bedroom unit or the 1-bedroom unit. That is not. It's not so. It's not the same with the assessments. You own a percentage of the common elements based upon the size of the unit, and you are obligated to pay money based upon the size of the unit, but you only get 1 vote per unit. So, query, if you combine 302 and 303, do you get 2 votes or 1 vote if you've now declared it to be 1 unit?
Now you, 1 unit would be 1 vote.
1 vote, right?
Yeah.
It's done. There are places where it's done. Pointing to Americas has many of them that have been combined. They're beautiful. They're, it's 4A and 4B or things like that. It does have to be allowed by the association, and it's done. Theoretically, you could buy 2 lots together in a homeowners association, but the same thing, be less likely.
So, and that's not just residential, isn't that how the industrial parks that have, the small bay industrial parks that are individual owners?
Condos?
Yeah.
Okay, so industrial's a little different because in commercial, I'm not gonna say industrial, commercial's a little different. And actually, that's a good bouncing point. I didn't think about this, because you don't see it so much anymore. The problem with owning commercial condominium units is a lack of flexibility. So if you have a business, let's say you're in, whatever your business is, whether it's retail or services or manufacturing, if you're lucky, your business grows. But if you own a box in a commercial condominium, and your neighbor owns the box over here and he has a business here, and another guy owns the box over there, you can't grow. So, that becomes a problem. Also, in the typical condominium, the way I described it for the residential condominium, that box is defined by that condominium survey. You can't necessarily alter that. You can't, unless the declaration allows it, you can't say, I'm going to take unit 101 and half of unit 102. There's a solution to it. The solution to it is a grid condominium, where the units are described, and I'm not going to hold, this is a little deep, but the units are described as, let's say, 10 square feet. So you would buy 20 units, and that would be, and then that's where your walls would go. And so if your neighbor wanted to contract, if the neighboring business said, I don't need as many square feet as I have, I'll sell you 10 grids, 10 squares, and we'll move the wall over 10, whatever number of feet. Now, you're not having a problem with amending the declaration and doing all of this stuff because you've got a grid established. Just like the grids on the carpet under your feet.
So then, like in this grid, do they separate it out into common areas, or?
Common areas are always separate from units.
Right. I follow, but then so it's grids. So you've got 10 square feet in this unit, right? Instead of 2,000 square feet.
Let's take the rows here it's a good example. So you have 3 rows in your unit, and you need a 4th row. The only issue is going to be ingress and egress if you need an extra door, and that should be relatively easy. So it would not really involve common area, because the common area is out in the hall.
Right. I'm trying to think. So then you just do that proportionally for cans as well.
It's by number of units you want, number of grid units.
Got it.
Okay? Any other questions?
That's not common practice, the grid?
It's, again, commercial condominiums are not as popular as you'd think because of the lack of flexibility. That was something that some of the more innovative people wound up doing to try and provide the flexibility. Occasionally, there are professional practices. So if you're, let's say, I have some clients who are dentists. Typically, unless you have more people coming in, if you're a dentist, you need an operatory, and a place for your hygienist to work, and maybe a second operatory for the person in waiting to do that, and then a little office area and a reception area. So that's relatively finite, unless you're going to bring in associates to come work with you. Same thing, well, law office is different because law offices are always growing and contracting. So maybe for that kind of a practice, you could do a commercial condominium. Other than that, it's difficult. They're out there. All right, any other general questions?
Affordability. You said it's not the ratio, it's the actual number.
Yes, correct.
Okay.
Go on the Broward County Property Appraiser's website, there's a calculator. Yes. Your notes are your study guide. I'm not here to hurt you.
And is it
I'm not
so-
Dr. Forty, I'm not going to be mean. I'm not going to dress in black for the exam, I promise. No, when I came here, somebody was complaining when they did.
With sunglasses on.
Somebody was saying how he gave a torturous exam, and I said, oh, of course he's going to torture his test, and we'll laugh.
Just for our funerals, that's what it is.
Again, I'm trying not to make the questions as rough seas as they were, but some people were complaining about them. Though some of you that are paying attention and doing, there were a few good, solid, raw scores. Curve breaker even. That made it hard, I will tell you. Don't apologize, smile. That made it hard. Because I couldn't just do a straight up bell curve. I would never do it. I was scarred by the lower. I don't think I can do that. I don't know how to do that. All right. Kill it. Please. Bye.